When you do what we do, you end up representing a lot of children. And by children, I mean anyone under the age of 18. They're a little bit different at the end of a claim than your normal adult would be. Typically, we would cut an adult a check for their settlement proceeds, and that would be that. When a child is involved, however, many times we need what we call a prove-up hearing. That is where we file a quote-unquote friendly suit and have the court, who now has jurisdiction, appoint a guardian ad litem. That can be any attorney who's qualified to serve. That guardian ad litem will then go through the case file, take a look at everything, and make sure that that settlement is fair for the child. He'll also talk to the child. He or she will talk to the parents of that child, go through all the medicals, make sure that there's no other issues that haven't been addressed. What they'll then do is make a recommendation to the court as to where the money goes. We don't cut a check directly to children, and we don't cut it directly to parents because parents can go spend it on themselves and it's not protected. So the court wants to see this money protected. A lot of times that can look like an annuity. It can be put in some sort of a trust depending on the amount, or it can be put in the registry of the court, which is essentially a savings account until the child turns 18. So those are some of the different options that we see and that we deal with whenever a minor is involved in a crash or some other type of incident, and at the end they are not yet 18. So children are always different, and certainly when you deal with the proceeds from the end of a personal injury case.